Let's learn about implications of today's Supreme Court Defense of Marriage Act ruling for tri-state residents with attorney Angela Giampolo, chair of the Gay and Lesbian Lawyers of Philadelphia. Thanks for joining us this evening.
Absolutely. Thanks for having me.
What are the obvious implications for same-sex couples regardless of the state they live in?
The 13 states where there is gay marriage currently will have those 1,138 federal rights. Social Security survivor benefits, taxes, pensions, immigration. So all of the 1,138 rights that affect same-sex married couples, but within the 13 states that currently have same-sex marriage.
And that includes Delaware, and those rights kick in 5 more days.
Exactly. Yep. But unfortunately, there's 2 other types of states. There's states like New Jersey, Illinois, Colorado that have civil unions. And then there's the states like Pennsylvania that have nothing.
To the extent that it's still a patch quilt, it seems confusing whether this will apply to same-sex couples who were married in one state and then moved to a different one.
Right. So it's confusing mainly because each agency within the federal government applies how its benefits are going to be applied differently. So, for instance, the IRS and the Social Security Agency use what's called the place of residence standard. So depending on where you reside with your spouse, that determines whether or not you get certain tax and Social Security benefits.
And you take that with you when you move?
No, because when you move, you've now changed your residence. So if my partner and I were to go and get married in New York and then come back here to Philadelphia, the majority of those federal rights we would not have access to because they are under the place of residence standard. However, there are some agencies that use what's called the place of celebration standard. In other words, where did you celebrate your marriage? Where did you get married? So Angela got married in New York, but she's a Pennsylvania resident. It's okay. Immigration is one of those agencies. So if my partner were about to be deported and we were married in New York, we would be considered married vis-a-vis the immigration laws, and we could get married and potentially avoid deportation. So place of celebration and place of residence, people have to look at what federal right they're looking to avail themselves to, then look at what that agency, how they define marriage, and then that will determine whether or not you here in Pennsylvania have access to that privilege or benefit.
Interesting, though, with Delaware, it's also a corporate haven. Does that put more of an onus on those employers?
Absolutely. I mean, but, the Fortune 500 companies actually wrote an amicus brief in support of the repeal of DOMA, because really what we have until we have uniformity, as of today, we have created 3 classes of citizens. We have straight people that are married. We have gay people that are married in New York and live in New York. And now we have a 3rd class of citizens that may be married in New York but live in Pennsylvania. Well, Google works in all 50 states. What does Google do with this? They literally have to create a whole nother set of books for those people in terms of their health benefits, in terms of, employee benefits and whatnot. So the companies, the inefficiencies and the costs associated with literally having 3 classes of citizens, that was a huge impetus behind their amicus brief. And obviously, they're all mainly headquartered in Delaware.
What do you foresee being the heavier lift in the short run? That work on Google's part to maintain those separate books, or uniformity, as you describe it, across the land?
It's going to happen mainly on from the corporate side and the state-by-state side. I don't think we're going to see uniformity, in the coming couple years or anything like that. So the fight still has to continue on a state-by-state basis. Right here in Pennsylvania, we have work to do. And then likewise on the corporate level, because money talks. And hopefully, I would say in 5 to 7 years, there will be uniformity in some way, shape, or form, whether it comes down from another Supreme Court case. I mean, my prediction in terms of how this is going to be dealt with in the future is there may not be another marriage case that goes in front of the Supreme Court of the United States, but there are cases right now with couples that are, let's say, married in New York, but live in another state and don't have access to, there's one here in Pennsylvania, a loss of consortium case. So lesbian couple, married in New York, personal injury matter, and they can't avail themselves in the personal injury matter to loss of consortium, which what that means. It's the loss of your loved one, being able to talk to them, intimacy and whatnot. Straight people can sue for loss of consortium and usually get a lot of money in a personal injury case. Well, this lesbian couple can't because they're not considered married here. There's another very interesting case out in Kentucky, lesbian couple, married, and there's the husband-wife privilege where, if you're married and you say something to your spouse, right, so you kill someone, but you were married a year ago and you kill someone yesterday, and you tell your wife that, she doesn't have to testify against you. She can invoke the husband-wife privilege. Well, that's happening in Kentucky, lesbian couple. The woman murdered someone 2 years ago. I never fully understood the husband-wife privilege to begin with, so I'm not arguing, that this is even a right law. But
it's a law.
But it's a law, and so the prosecution is forcing the lesbian partner to testify against her spouse. I mean, they're legally married, but in another state. So I think those are the very interesting cases that are going to start creeping up, and eventually the Supreme Court will see, and the country will see this hodgepodge, this quilt that you mentioned, is fundamentally unconstitutional.
Even if the Supreme Court ultimately continues and now and forever to dodge the fundamental question of the fundamental right to marry.
Right. Do we have a right embedded in the Constitution to marry? I mean, I'm French-Canadian. I'm dual citizen of the U.S. and Canada, and I grew up in Quebec mainly, and Canada rewrote the Constitution 9 years ago to make marriage gender neutral, amended the Constitution of Canada to make it gender neutral. Since the oral arguments in March, we've already had 2 more countries legalize gay marriage, France and Uruguay. I mean, it's happening already globally, and I believe it's happening within the United States in terms of the societal pulse and the people. But our legislature and our Supreme Court have to get there next.
Of course, this just went down today, but do you see today's action as another step in the process or a major catalyst?
I see it as a major catalyst. It wasn't a Brown v. Board of Education sweeping ruling where overnight 38 state bans against gay marriage are going to be deemed unconstitutional. But, a lot of people don't realize Loving v. Virginia, the case where interracial marriages were once not allowed, and Loving v. Virginia found that unconstitutional. That case actually went in front of the Supreme Court first in 1952, when there were only 13 states allowing interracial marriages. Very, very similar to today's landscape, if you will. And then it went back in front of the Supreme Court 12 years later in 1964. Civil rights movement was happening. It was a whole different societal pulse and feeling around civil rights. And at that point, there were only about 14 states that were still disallowing. And the Supreme Court said, you know what, we left it to you for long enough. You didn't get it right. We left it to the states for 12 years. And in the states, guys, you just didn't get it right. We have to do it for you. So, I think we still have some work to do, but it'll happen soon.
We are moving more rapidly to the extent that it was 10 years ago today that the Supreme Court finally struck down anti-sodomy laws as unconstitutional invasion of privacy.
Right. And Justice Kennedy gave us both of those opinions. I've been talking to people on this issue, and I would say Justice Kennedy loves 2 things: gay rights and states' rights. Right. And that's ultimately what we got here today. I don't think the Supreme Court was ready to tell the states, big brother, federal government, this is what you need to do. But in that opinion, there's definitely some strong language there that if there are fights that go up to the state Supreme Court, let's say in Pennsylvania, and goes all the way up to the state Supreme Court, that state Supreme Court of Pennsylvania can look to this Supreme Court of the United States on this issue. This is, in my opinion, a monumentous, step forward. And Justice Kennedy gave us both of those, so I'm sure he's pleased with himself here today on both, the Lawrence v. Texas and now today.
Angela, thanks so much for joining us this evening on Newsworks Tonight.
Absolutely. Thank you so much.